sticking out from under the seat.
Okay. Now, to be clear, this white Ford pickup truck, is it the same Ford pickup truck that you observed in the video?
It appears to be that vehicle, yes, sir.
And the defendant who's in the courtroom today was driving,
Yes, sir.
and a pistol that you observed was underneath the...
Yep, underneath the driver's seat, you could see it in the floorboard there.
Okay. And what type of pistol was it?
That was a Glock 19.
A Glock 19. And you collected it?
Yes, sir.
And it was submitted to the TBI lab for testing?
Yes, sir.
All right. Your Honor, may I approach the witness?
You may.
Detective, can you identify this guy?
Yes, sir, that's a property receipt
And
that was written for Mr. Kyle Bush and the pistol, the Glock 19.
when was it taken out or issued?
October 30th, the same night.
2025?
Yes, sir.
And that identifies the Glock 19?
Yes, sir, there's a serial number on it.
All right. I'll make that the state's next exhibit, please. 13. I'll pass the
Exhibit
witness.
13. You may cross-examine.
Detective Morgan,
Yes, ma'am.
how long have you been a detective with the Dixon County Sheriff's?
Since 2013.
All right. So you're really knowledgeable about different things that go on and the policies and things that are distributed to sheriff's deputies.
I would say so, yes.
What kind of guns do y'all carry?
Okay, Glock 19s.
Glock 19?
Well, I carry, if you ask me personally,
Uh-huh.
I carry Glock 19, yes.
Same exact gun that this was?
Yes, ma'am.
And same exact, so it would use the same ammunition?
Caliber?
Yes?
Yes, caliber.
Okay.
I don't know what brand.
How many sheriff's deputies do you think carry Glock 19s?
Think some of our patrol carry them. Not all of our detectives carry them. We're in the transition to changing right now.
All right. And,
So I don't have an exact number on that.
okay. And did you said you just submitted it into evidence? You didn't do any of the testing or anything?
No, ma'am. I collected it when he was taken into custody.
All right. And you picked him up on the warrant, and you said you picked him up on the warrant on 10/30/25?
Same day that's on the sheet. I think so, yes, ma'am.
Okay. Do you happen to know what date the incident happened?
I'm not privy to it, but from what I remember, it was earlier in October, a few
Okay.
days before.
Okay. And while you don't know the exact one, several days had passed between the incident and
Yes, ma'am, a few days had passed, maybe a week.
I have no other questions, Your Honor.
Redirect.
Detective, in your many years' experience with the sheriff's office, I'm not sure that the defense attorney was aware that you are a certified Glock armorer.
Yes, sir.
And being such, you know that each Glock 19 creates independent and unique strike marks. Is that correct?
Yes, sir, they do.
So
Each
if
one.
everybody in the sheriff's department carried a Glock 19 and they all fired one round and we collected all these shells,
Yes, sir.
each Glock 19 would create its own unique, independent strike mark based on the ejector, pin, and firing pin.
The ejector, the extractor, and the firing pin, yes, sir. Each weapon has its own fingerprint,
Each one is unique.
every weapon.
Thank you.
Thank you. You may sit down.
Thank you, sir.
State may call your next witness. We'll come around. I'm going to ask you, I remind you rather that you were placed under oath earlier, so you remain under oath.
Ms. Richards, just some follow-up. You were asked some questions, and some of the other witnesses were asked questions about bruising. What's on your arm?
I have a tattoo from here all the way to the end of my arm.
Okay. Did the defendant strike your arm or
Yes.
grab your arm?
Yes.
Were you bruised?
You can't see any bruising if I did have any because of the tattoos.
Okay. You have a tattoo from, I think you indicated, your shoulder,
Yes, from the top of my shoulder all the way down to my,
and is it complete tattoo?
yes.
No, you can't see skin?
Unless you go to the inside of my arm.
Okay. but where he grabbed you or where he struck you.
Yeah. You cannot see.
So would you know if there was a bruise or not?
No.
All right. Do you know, was there a bruise? But you know he hit you.
Yes.
All right, let's talk about the strike on your face. Did he strike your face?
Yes.
Did it leave a bruise?
Not that I can see, but it just happened the night before.
Okay. What do you mean it just happened the night before? Why is that relevant?
Because the time, I mean, some people bruise, some people don't, but also the time that it takes for a bruise to actually form and the stages of what a bruise can look like. Bruises can turn yellow, which means indicates that that's an old bruise, but time is a very important factor. It just happened the night before.
Yeah. He hit your face while you were driving.
Yes.
And obviously he didn't hit you hard enough to knock you out.
Right. Or for me to lose control of the car. I didn't wreck. I made it home safe.
Yeah. So we know the strike had to have not as much force as it could have.
Right.
Have you ever in your life experienced bumping your hand or leg or face or anything on an object and it not bruising?
Yes.
So that happens. You
Yes.
can be struck or bump into something and no bruise appear.
That's correct.
All right, thank you.
Recross?
You talked about some people's bruising and how some people's bruising looks. How does your bruising look?
If I were to bruise, it would be a little swollen and it would be like purplish.
Okay. And how many days does it take for you to bruise?
I can't answer that. I don't know because I can't remember the exact time that I last had a bruise.
Okay. So you didn't have a bruise during any of this, or you would remember it? It was a couple weeks ago, right?
When I made my report, there was no bruise on my face. Yes.
Well, was there ever one?
No.
Okay. And we saw some pictures of chunks of hair, stuff like that. And you testified earlier that he pulled out chunks of your hair.
You pulled my hair. Yes.
Do you have any bald spots?
I wouldn't say bald spots. No.
Okay. I have no other questions, Your Honor.
Jurors have submitted a question, and the question, again, would be considered by me outside the presence of the jury, but the jurors, one of the jurors has asked, if you say you were driving while he pulled your hair, why wasn't the hair in the driver's seat? Either one of you want to ask that question or allow me to?
Richard, you say he pulled your hair while you were driving?
Mm-hmm.
And I believe one of the photographs that's been introduced is literally your hair on the driver's seat.
That's correct.
Corroborates what you were saying.
Yes.
And your hair was in 2 other locations?
Yes.
Did you stage this incident?
No.
Did you pull your own hair?
No.
And did you hire a driver to get in a white pickup truck and drive by the sheriff's office and fire 4 shots out the window?
No, sir.
You didn't make this up.
No.
All right, I'll pass the witness.
Recross?
You're under oath, right?
Yes, ma'am.
And when you took that oath earlier, did they say that if you were to not testify correctly, you could be punished, correct?
That's correct.
So it wouldn't be very beneficial for you to say right now that something you said was incorrect, right?
I didn't say anything that was not correct.
But you would be punished if you had, right?
Absolutely.
So to ask you if you are telling the truth, if you had not been, now wouldn't be a very good time to admit that, right?
It's kind of confusing me. I know that I'm under oath and that everything I've said is the truth.
I have no other questions.
Richard, you voluntarily, willingly took the stand today,
Yes.
knowing you're under oath.
Yes.
Is that hard to do,
It is extremely hard.
to tell your story in front of a group of strangers?
Yes.
How does that make you feel?
Vulnerable,
Vulnerable.
terrifying.
And everything you've said today has been the truth.
Yes.
And I appreciate you being here today and being willing to actually testify in front of the jury. Thank you.
Thank you.
Mr. Crouch, any other witnesses? State has rested, ladies and gentlemen. At this stage, the next step that would happen in a real trial would be I would ask the jury to step across to the jury room, and then I would consider what's usually called a motion for judgment of acquittal. The defendant has the right to file a motion or make an oral motion for judgment of acquittal to be, it's basically like, there's not enough evidence to convict me and I want you to stop this trial right now. And that's almost every case, every criminal case, the defense will make that motion for a judgment of acquittal at the close of the state's proof. So we hear those motions, and I think in my 11 years on the bench, I have granted one of those judgment of acquittal motions because even the state, I think, agreed that there was not enough evidence. But normally that's denied, and you have to, when a judge considers it, the judge has to consider the evidence in the light most favorable to the state. In other words, take the strongest view of the state's case. So I would deny your motion for judgment of acquittal, Ms. Sylvie. Then step up to the podium and argue that motion if you want to. So.
I would love to, but I don't have a formal indictment, so I'm not 100% sure which counts I'm arguing it against.
Domestic assault. So
That's the only count, one count.
that's all that I know of.
Well, only thing I would say is we have to do an election of offenses because we've had testimony to 2 different dates and we have 1 count.
This is what happens when you get an experienced prosecutor that act as a defense lawyer. They make it more difficult for all of us to do a mock trial. So your motions are all overruled, period. So, all right, so the next step would be for the defense to put on any proof that they want to. Does the defendant wish to offer any proof?
Your Honor, my client would like to waive his right to testify.
Then I would, while the jury's out, I would have asked that question. So we'll now ask Mr. Bush to come to this podium, and I will conduct what's called a Momon hearing. That is basically a hearing that I have to ask the defendant questions about his right to testify, and it's based upon a case, I think it was United States versus Momon or something on that order. I'm not actually sure where that comes from, but Mr. Bush, raise your right hand. Let's fake having you placed under oath. State your full name for the record.
Kyle Bush.
Mr. Bush, you are here today as a defendant in this case, and I want to make sure that you understand your rights. Do you understand that you have an absolute right to testify at your trial on your own behalf?
Yes, sir.
And if you want to testify, do you understand that no one can prevent you from testifying if you desire to do so?
Yes, sir.
Do you also understand that you have an absolute right not to testify under the Constitution? And if you choose not to testify, no inference of guilt will arise with a jury, and no one can make you testify if you don't want to do so. Do you understand that?
Yes, sir.
Have you talked this over with your lawyer?
Yes, sir.
Have you and she discussed your options and what is in your best
Yes,
interest?
sir.
Having discussed it with her, what is your decision? Do you wish to testify, or do you
Yes, sir.
waive that right?
I'll waive that right.
All right. Then I would say that you're waiving your right as knowing and voluntary, and we will allow this case to move forward. So,
Yes, sir.
all right. Then I would bring the jury back, and I would, on the record, say, Ms. Sylvie, does the defendant wish to offer any proof?
Your Honor, the defense would rest.
The defendant waived any proof, and so the state would have the right to then make their closing argument to you. State wish to make a closing argument? No, I was going to get them to give you a portable microphone. Certain lawyers are very good at communicating with the jury. One of the ways of doing that is instead of just standing motionless and behind the podium, they want to walk around and engage with the keep you awake while they're talking. Mr. Crouch is well known for that. He's famous for it, in fact, but he wanders away from the microphone. So we're going to get him a portable microphone for him to hold while he's walking around talking to you.
I'm from a different jurisdiction before I'm here now. Where I previously was, we had you cannot get an arm's length from the podium. So I'm probably going to stick a little bit closer to the podium so you can hear me. If the only thing you need is the gun and the ballistics that says this matches this gun, why did we hear and have everything else that was presented today? If that's all you needed, why did we hear everything else? Let's go to a couple different things. We're to believe that someone is absolutely terrified of someone, has keys to their car and a phone, and invites that person or allows that person, whatever word you want to use, get into the car and drive home with them. You have taken this person that you're supposedly so scared of, allowed them to get in your car and drive home with them to a secluded place. That makes no sense. That makes absolutely no sense. The state has the burden of proving here. While he says I make suggestions, the burden is actually on the state. They're the ones that have the burden and the duty to prove beyond a reasonable doubt that what they said happened the way they said for this person to be found guilty. So let's go back to that. So scared, you let him in the car or allowed him in the car, and instead of staying put in a public place, drove home. Had your phone on you the whole time and never called anybody for any type of help. She also had no bruising. She admitted that she had no bruising. Why wouldn't we have bruising if this happened the way that she said? No bald spots or anything like that for the hair. The hair, that's another thing that was said. While she was there earlier in the day, the hair was collected at night. I asked about whether or not the vehicle was secured during that time frame. The only way that they secured it was they were knowledgeable that it was outside. Was it locked? Was it unlocked? And again, it's her hair in her car. I'm not completely moved by that. Speaking of finding her hair in her car, one of the things, the only thing we really need is the matching of the gun and the bullet, according to the state. But we have a lab report of DNA. The state spent a whole lot of time proving that she was in her car. Wow. You know who they didn't prove was in her car? Mr. Bush. There's no DNA for Mr. Bush being in the car. But a lot of time and effort to prove that her DNA is in her car. The air tag. We have an air tag. No one can tell you when it was placed. No one can tell you who accessed it. No one can tell you what email addresses were used. And we were talking about a text message about Life 360. Well, if you have an air tag, why do you need Life 360? Why would he care that Life 360 was turned off if you've got an air tag tracking someone? Again, all this proves absolutely nothing. The video was up there and it's no longer up there, but we still have some still pictures. And in that, one of the things that they talk about with this bullet that matches with the gun, the casings were found in a part of the parking lot that the truck was never even in. The truck was never even in that part of the parking lot. And there was 4 casings found, completely different parking lot, where if someone had fired out of the driver's side, we talked about it would be all the way over on a different side of the road in the trees and everything. No one found any casings over there. Are we to believe that they went out of the car, over the car, under the car, through into the other parking lot? And the gun that it matches to was found 6 days later. So it matches. Great. Did anybody prove that that was his gun? Yeah, they found it in his car. He was in possession was the word that they used. How did it get there? It had been 6 days. Did anybody prove that he went and bought that gun? There's a picture of the gun. Did you see the gun? Does it match the gun that was in the picture that was sent in the text message? No. State has the burden to prove all of that, and they have not done that for today. I submit to you that Mr. Bush is not guilty.
All right, ladies and gentlemen, the next step would be in a real trial for me to hand you your own individual copy of the last instructions I'm going to give you. And you would have been given a copy at the outset of the trial as well when I gave you some initial instructions. But I'm just going to kind of wing it and give you some basic instructions before you retire to deliberate. Ladies and gentlemen of the jury, this will be the final instructions of the court. The defendant, Kyle Bush, is charged in this indictment with a crime of domestic assault, and I'm only using that because there could have, in a real-world situation, the firing of a weapon would have constituted aggravated domestic assault, which is a more serious charge. But we're dealing with domestic assault because I don't think we specified or elected it. So anyway, he is charged with the crime of domestic assault. necessarily included within those offenses could be some lesser included offenses, which I won't go into. That's more complicated than you need to worry about. The evidence and arguments in this case have been concluded, and it's my duty now to instruct you on the law. The law applicable to this case is stated in these instructions, and it's your duty to carefully consider all of them. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if been committed, was committed by the defendant in Dixon County, Tennessee, and it was committed before the finding and returning of the indictment in this case. As heretofore stated, the defendant is charged in the indictment with the crime of domestic assault. Any person who commits a domestic assault upon another is guilty of a crime. For to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to Miss Charlotte Richards, and that the defendant acted intentionally, knowingly, or recklessly. I would then give you a set of instructions that define what bodily injury means under the law, recklessly and knowingly and intentionally mean under the law. If you find the defendant guilty of domestic assault as charged in the indictment, you shall so state. Or if you have a reasonable doubt as to his guilt, then you must find him not guilty of this offense. And if there were other charges, you would then go to those other charges. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another, to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, don't hesitate to re-examine your own views and change your opinion if you're convinced it's erroneous. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render a verdict as absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you'll first select one of your members as a foreman or forelady who will preside over your deliberation. When you have reached a verdict, you will return with it to this courtroom, and your foreman or forelady will announce it. There are some other instructions I would give to an actual jury, but that's going to conclude what I'm saying to you tonight. So we'll now allow you to retire to the jury room and decide this case. Now, ladies and gentlemen, this has been a very emotional trial, and I understand that emotions can run high, and when the jury's verdict is returned, I'm going to caution you all not to show any outbursts, not to have any outbursts of emotion. The jury has done a good job of listening and paying attention, we hope. And as a result of that, I want them to be treated with respect. Bring the jury in, please. And that goes for you, Mr. Defendant, as well. So, did you have a shock vest on him? All right, ladies and gentlemen, everybody be seated. I'm told that the jury has been able to reach a verdict. Is that correct? Then will the foreman or forelady stand and let me go over the verdict with you. As to the count of domestic assault, how did the jury find the defendant? Not guilty or guilty? Not guilty. Is that the unanimous verdict of all 6 of you, 5 of you? Then if you, all right, ladies and gentlemen, the jury having found you not guilty, and General Sylvie having been demoted in her office with the district attorney's office, we thank you for your time. So thank you for your help and time. So now you can go home and go to sleep. So that concludes our mock trial for tonight.
Thank you, guys.
You are welcome. Let me say this to everyone here. I don't know if you've actually sat in on a real trial before, but you had the benefit tonight of having 2 excellent attorneys, both of whom happen to work for the district attorney's office, but they both did a very good job of presenting the proof in the limited time that they had to look over the facts of the case. So you're lucky to have 2 good lawyers who helped us with our trial today. Ladies and gentlemen, we are concluded. Good night.